Hi folks, my name is Dan Richardson and I've been an immigration attorney for over 8 years. I want to thank you for visiting my website and for being interested in the types of legal services that I provide. I help people in danger of losing their rights to get legal immigration status. As an overview, I do primarily family immigration as opposed to employment immigration. I really help people mostly with lawful permanent residence or green cards. I do this through adjustment of status, deportation and/or removal defense in the Executive Office for Immigration Review. I help people get citizenship through the naturalization process. I help with fiancé visas, the K-1 visa, and I help with marriage visas, the K-3 visa. In terms of family immigration, I help petition a close relative for you. I help petition for a fiancé visa, the K-3 visa, the K-1 visa, and I petition for a spouse and or child visa, which is the K-3, K-4 visa. I also help petition for relatives to enter the United States with a green card. So the requirements for a fiancé visa, the K-1 visa, are that the petitioner must be a U.S. citizen, the petitioner and the applicant must be free to marry, the applicant, who is the fiancé, must meet standards for health and lack of criminal background. The applicant must have a valid passport in their home country. The petitioner and applicant must have met in person at least once during the previous 2 years. And the petitioner must meet the income or asset requirements for an affidavit of support. I go into all of these details on my site, and I would be happy to discuss the details of any of these issues in person, or by email and by phone. I help primarily with adjustments of status for clients who are entitled to that. And this is where you change immigration status to a green card in the United States. The primary requirements are that you must have an immediately available visa, which the spouse of an American citizen would have, and you have to have entered the country legally. The players here are the petitioner, who is filing a request for the spouse or for the person to get a green card or adjust their status here in the United States, and the applicant, who desires to change their status here in the United States. If you are placed in immigration court proceedings, you are facing potential deportation and or removal from the United States. You will want to put up a defense to this in order to remain in the United States, and I help people with this. The primary defense is, or the thing that initiates the process, is called a notice to appear, and this will be issued by U.S. ICE, U.S. Immigration and Customs Enforcement. You are, with the notice to appear, you are placed into the Executive Office for Immigration Review, which is the immigration court. The first step is a master calendar hearing, at which point you present your defense. You then have time to prepare your defense and make any court filings in support of your defense. And then you will have an individual and or often called a merits hearing where you present your defense. The immigration judge will then issue a ruling. If you prevail and you win on your defense, you are going to be awarded whatever relief is appropriate for your defense, and you're done. If you were denied that opportunity, or if you were denied your defense, in other words, you lost, then you have the option to appeal that to the first line of appeal, which is the Board of Immigration Appeals, also known as the BIA. If you lose at the Board of Immigration Appeals, you can still appeal that to the Circuit Court of Appeals, the Federal Circuit Court of Appeals. Let's talk about how to become a citizen. This is also the naturalization process. You must have good moral character for the prior 5 years to the filing of the application. You also have a 5-year waiting period from when you are granted your green card before you can apply for naturalization. If, however, you had been petitioned by a U.S. citizen and were awarded your green card through that petition, you can apply for the naturalization within 3 years. You do this by filing a naturalization application. There is a very thorough background check to support the application, and this is performed by the Immigration Service. You will then have a naturalization hearing, at which point in time at the hearing there is and I call it a hearing, it's also an interview. At the interview, you will have a small test on the English language and a small test on civics, civics being the structure of the government in the United States. You can appeal it if you are turned down. So let's talk about the fact that your needs are special. Every case that I've dealt with has unique factual situations that make them different than everybody else. I offer a free confidential evaluation of those facts and the law, and I am licensed as an attorney to practice immigration in all 50 states. To get your free initial phone or email consultation, simply call toll-free at 800-526-7974, or you will have an opportunity to make a request by email on this website. Thanks for your attention, and thanks for visiting my site.